Jain Gupta, former ED of Sebi, joining us from Mumbai. Mr. Gupta, thank you very much for joining us. Just wanted to, can you take us through what is the kind of remedy that FTIL may have in order to contest this Sebi order?
The remedy is available against all the orders of SEBI, and the first remedy is that they can move to honorable SAT against the order, and if they are not satisfied with the order that SAT passes, then they can move to honorable Supreme Court. So it is not any special order, it is like any other order of SEBI which can be challenged.
Mr. Gupta, this is the second time SEBI has come out with a not fit and proper order against FTIL and its entities. The first order being the K.M. Abraham order, which was set aside by the Bombay High Court. The second order, which is today's order, is based on the order passed by the Forward Markets Commission. How tenable will it be in the court of law? Because SEBI is basing its argument saying that any impact on commodities market will have an impact on the securities market as well, and hence this order holds firm. And they are right in saying that FTIL and its entities are not fit and proper.
See, it all depends what are the details in the SEBI order. How SEBI has determined this time that what are the considerations on which they have treated FTIL and Jignesha as it's not fit and proper. One cannot link the previous SEBI order with this order. And secondly, even if FMC would have passed an order, SEBI must have passed a speaking order giving the reasons why they treat them fit and not fit and proper. Of course, the SEBI logic that a person who has been found unfit by one regulator is likely to be unfit for the second regulator as well, because the financial markets are integrated. You can't isolate one market from other markets. So, because of the contingent effect, SEBI would be very much within power to say that yes, they are not fit and proper. But it all depends what are the contents of the order and whether those contents can be will pass through the eyes of SAT or Honorable Supreme Court.
Mr. Gupta, stay with us. We have Mr. H.V. Ranina as well, senior advocate from Supreme Court. Mr. Ranina, just want to check with you. SEBI has given them 90 days to divest the stakes in various stock exchanges. Can the board of these exchanges suo motu take action and divest the stakes, or they will have to wait out the 90-day period before acting?
No, they have been told to divest within 90 days. So the question of waiting doesn't arise. They will have to start the process immediately. But in case they are not able to do so for whatever reason, then they can always make an application to SEBI again and ask for extension of time. So I think the process must begin immediately, and they will have to convince SEBI that this is what is being done, that they're taking adequate steps to do that.
But can the board of these stock exchanges take any action or can they initiate a proceeding wherein the stakes are divested, or it will be up to FTIL and its entities to do it?
For the first 90 days, they will have to give an opportunity to FTIL to do the same. They can't take preemptive steps. The stock exchanges can't do it. It's only if they fail to do so that some action may be taken against them as may be decided by SEBI. But just now, FTIL will have to act on its own.
Mr. Ranina, there is a case going on in the Bombay High Court where FTIL and its directors are challenging the not fit and proper order issued by the FMC. Given that in the background, and SEBI coming out with its own order, will FTIL be able to club both the cases and take it to Bombay Stock Exchange, or will it be done in two separate, one in SAT and one Bombay Stock Exchange?
No, they will have to make separate, their separate cause of action. So they will have to make a separate application in each case. Clubbing may not be relevant also. So I think they will try to act in a manner which gives them the opportunity to come twice before the various authorities. So I don't think there will be any issue of clubbing the two. It will have to be done separately.
And do you think in that case it will be a long drawn process before any finality comes to it?
Well, I would say within the next 6 months things should get resolved. It can't go on beyond that. So unless, of course, they again then go further to the High Court and then to the Supreme Court, then it will be long drawn. But at the appellate stage, should be over within the next 6 months.
But can the appellate stay the entire SEBI order till finality comes to the entire FMC order, or the challenge to the FMC order in the Bombay High Court?
Well, that's for the Bombay High Court to stay the SEBI order if they feel that it is prima facie wrong. So again, it is at the discretion of the High Court whether to stay the order or not.
Mr. Gupta, just to bring you into the discussion, what is the way forward for FTIL as far as the stakes in MC's Essex is concerned? Because you have a rights issue which is going on, and most likely post the rights issue you will have FTIL holding more than 2% because the entire rights issue may not be subscribed fully. In such a scenario, will the board of MC's Essex still wait for FTIL to divest the stake? Because
Hello?
yeah, Mr. Gupta, can you hear me?
Yeah, I can hear you. So, first of all, as far as my knowledge goes, the board of MCX Essex cannot take any action to disrobe FTIL or the Jignesh of their shareholding. They will have to come back to Sebi that this order was passed, and unfortunately of this stake of Jignesh or FTIL or MCX Essex, MCX had not come down in MCX Essex as directed by Sebi. So they will seek direction from Sebi because board did not have any regulatory power per se. As far as their way forward is there are only two ways forward. One, either comply with the order of Sebi or appeal against the order with honorable stat, or not satisfied, go to High Court or to Supreme Court till the order receives finality. So there are only two ways forward, either comply or fight.
And what happens, because FTIL also holds a stake in National Stock Exchange as well, and it holds more than 2% stake in National Stock Exchange, if I'm not wrong. Can the board of National Stock Exchange take measures to cap the voting rights of FTIL in the next 90 days?
See, all that action will have to flow from the bylaws or articles of registration of National Stock Exchange or any other stock exchanges. And if the articles do not permit, then they can go to Sebi and say that this is the situation where this shareholder of ours has been treated as not fit and proper. Advise what is to be done. Because if I remember the earlier Sebi regulation for the minimum public shareholding in the stock exchanges had some provision for Sebi forcing the dilution. But I do not recall, or I do not remember what is the real provision in the new law. So I will not be able to comment on that.
Mr. Gupta and Mr. Ranina, thank you very much for joining us. Elan, back to you.